Joining us now, former lead investigator on the January 6th Select Committee, Tim Heaphy. Tim, thanks for being here. Tell me your reaction today to the D.C. Court of Appeals.
Not surprised, Katie. I don't think this is a close case. I think the arguments demonstrated that. I think the opinion conclusively shows that, that no person is above the law, that the criminal statutes, if proven, and that's obviously yet to be determined, should apply to anyone who violates those laws. So all the way from the foundation laid by the Select Committee, this is another step toward resolution of that key question. Is this or is this not, beyond a reasonable doubt, criminal? And it brings us closer to that trial.
Why do you think this is criminal?
Because this was much more than rhetoric. This was much more than speech. This was a multi-part intentional plan, as we laid out in our report and in our hearings, designed to disrupt the joint session and interrupt the transfer of power. If this were simply, hey, the election was stolen, without action designed to actually bring about that result, it wouldn't be criminal. But it was the combination of the fake electors, the pressure on state officials, on the Justice Department, on the vice president, and then the rhetoric that launches the mob toward the joint session that together makes this, presents evidence of intent to disrupt the joint session. That's what's at stake. Intent, is there or is there not intentional conduct designed to interfere with that official proceeding?
When the Supreme Court considers immunity, what is your expectation for whether they're going to take it up and consider it in full, or if they're going to just uphold the Second Circuit?
Very hard to predict always with the Supreme Court. But I think this opinion, I was struck by how careful it is, how thorough it is. It considers absolutely every argument that the former president made, rejects them both with respect to precedent and policy. I think it is designed, it's per curiam also, it's unanimous, it's designed to potentially prevent the case from further review by the Supreme Court. I think, again, it's not a close case. The Supreme Court does not waste its time on things that if the lower court opinion or consensus is sound, and I think there's a very good chance that they deny cert here. And again, that just sets the calendar, would go back to when the case will be adjudicated by Judge Chutkan and a jury in D.C. So
the Supreme Court is also going to be hearing oral arguments on Thursday regarding the Colorado case, which says that Donald Trump is disqualified from the ballot because he participated in insurrection. They said that Article 14, Section 3 of the Constitution says that if you participate or if you give aid and comfort to, you can't run for office. This was in reaction to the Civil War, although they specifically did not say former Confederates. They said anybody looking forward to the future, knowing that this could potentially happen again, that the popular vote, the popular opinion could give rise to somebody who isn't exactly in line with our Constitution. When they decide whether or not Donald Trump participated in insurrection or whether or not January 6th was an insurrection, what's your argument for deciding yes to both those questions?
Well, there's a lot of evidence on which the Colorado court relied that supports the finding that the former president engaged in insurrection. And the Supreme Court, frankly, doesn't really review questions of law. They resolve, questions of fact. They resolve questions of law. So I think the Supreme Court on Thursday will assume that there is record evidence that supports the finding that the president engaged in insurrection. The question then will be, so what? Does the 14th Amendment, Section 3 of the 14th Amendment, give rise to authority to a state Secretary of State taking him off the ballot, unilaterally removing him from the ballot? Or does there need to be some sort of enabling legislation? Must Congress be the body that enacts that? I think there are uncertain questions of law, which makes that a closer case than the immunity case, which does not seem close to me. But again, the uncertainty is on the law, not really about the facts. And the Supreme Court generally does not review questions of fact.
Tim Heaphy, good to have you. Thank you very much.